Greetings, everyone. This is Professor McKenzie again. Today we're going to be looking at Chapter 21, which involves bailments and the storage, shipment, and leasing of goods. The overall learning objectives for this chapter, I want us to understand first what the elements of a bailment are. Then we're going to discuss the liability regarding the two participants in a bailment agreement, which is the bailor and the bailee, and I'll explain what those terms mean in just a minute. We'll talk about other rights and duties that bailees and bailors are entitled to. We'll talk about some special bailment arrangements. For example, when we talk about innkeepers or hotels as compared to other types of industries that are represented by these types of transactions. And then finally, we'll cover and discuss just a little bit about shipment of goods. So in general, as we kind of wind down the course, because we're slowly doing that now, some of the concepts that we're going to be covering in these last few chapters are going to be a little bit of a review from chapters we've covered earlier in this class. So if you start to see some concepts and you think, wow, that sounds familiar, there's a reason why. So just kind of know that. And so it does actually help some of these later chapters in the course, because since it is a little bit of a review on some of these concepts, then it just makes it easier as we go through the material. So anyway, let's go ahead and move to the next slide. So when there is a bailment agreement, what we're discussing or what we're referring to is that when tangible personal property is delivered by the owner, and we're going to call this person the bailor when we're referring to the bailment agreement, to another person who is going to be the user or the possessor of that physical tangible property, and that person is going to be called the bailee. So in this transaction, the bailee has possession of whatever the property is in question, but they do not have title, meaning they do not have ownership of that property. They just have the right to use it for whatever the term of the bailment agreement is. The easiest example, and I'm going to go through some other examples in some future slides here today. The easiest example is when you rent a car. You know, when you rent a car from any of the major car rental companies, that agreement is a bailment contract. Whoever the car company is, you know, they are the owner or they represent the owner of the vehicle. It could be, you know, obviously the fleet of vehicles. And then your arrangement or your agreement is that you're going to temporarily use that vehicle for, you know, a day, a week, a month, whatever the term is. And then you return the vehicle upon the, you know, stated due date in the agreement. And so that would be considered a mutual benefit bailment, because you're getting something out of it as well as the owner or the bailor is getting something out of that, because presumably they're charging you for that. So that's the key thing, just to kind of understand as we approach the topic of bailments. Understand that a bailment agreement is where the owner of some type of physical property, tangible property, who we're going to call the bailor, grants to someone to use that property for some specified term of agreement, and the person who's using or possessing that personal tangible property is called the bailee. Kind of some unusual terms of art, but you know, again, once you get the lingo down, then I think it makes it easier to kind of understand what's happening in these transactions. So the reason why, you know, once we understand the definition of what a bailment contract is, we need to understand it's the three major types of classifications of bailment. The reason why the classification is important to understand is because depending on the type of classification, that will indicate the burden that the user, the possessor, or the bailee, however you can kind of frame that in your mind, that's going to dictate the level of care that they're required to exercise while that property is in their possession. So you can see the three major categories where the sole benefit of the bailment agreement is to the bailor, meaning the owner. You could also have an agreement where the sole benefit is to the bailee or the possessor of the property, or it could be a benefit to both parties. So let's start with the last one. So I've already discussed the car rental situation, and so that's the perfect example of where you're benefiting both sides. You know, the car rental company is getting whatever the agreed upon fee is for the term of the agreement. You're getting use of the vehicle. And so, you know, We'll get to the next slide and I'll kind of explain the level of care required, but that's one kind of classification that I want us to understand. The middle category, it says the sole benefit is of the bailee or the possessor. This is where someone owns property of some kind, physical, tangible property, and they're letting someone else use it. And it's usually in the context of they're being generous, and so you don't have to pay me. I'm letting you use this property for some term, and at some point I do want it back though. So sometimes with this example I give let's say I have a brother, and maybe he's in between cars. Maybe he got into an accident and his car was totaled, and he's not ready to purchase a new car yet, but he needs something to drive around in temporarily. So I have a spare vehicle and I lend it to him. I'm not charging him. So the benefit of that bailment agreement is it's all on him. So he's using property that I own. I'm not getting compensated. So the benefit is all on him. It's a bailment because I'm not giving him the car permanently. It's not a gift. We'll talk about gifts later in this course, but all it is for some set period of time. I could, whatever we agree to. It could be 2 weeks, a month, whatever. But the benefit is all on him. I'm getting nothing out of it other than being a good brother. That's it. The first example, it says the sole benefit of the bailor. So this is again where someone else, is using and has possession of someone else's property, the owner's property, and they're not getting anything out of it. The person who's possessing it, they're just, they're just doing this as maybe a favor to the owner of the property. And so an example there might be, again, let's use my car example. Maybe I travel during the summer, and let's say I'm going to be gone for maybe 1 or 2 months, so an extended period of time, and I really don't want to leave my car just kind of sitting in the driveway. And so again, I go to my brother and I say, here, I'm going to give you the keys to my car and my car. Just keep an eye on it over the summer, and maybe start it up once a week, just so the car stays active. In that situation, my brother's getting nothing out of this other than being a good brother, and kind of just keeping an eye on my car while I'm out of town. So again, in all of these three examples, you see that property is being transferred from the owner to someone who has possession or use of that property on a temporary basis. And we're just trying to understand who's getting the benefit of this agreement. Is it all on the owner or the bailor, or is it all on the possessor or the bailee, or is it a mutual beneficial arrangement? So that's the kind of context I want us to understand when we think of these classifications. So because of those three classifications, now we can discuss the duty of care that the possessor or the bailee must exercise. So I'll just kind of go down the list top to bottom. So the sole benefit of the bailor. So for my brother who is just, watching my car while I'm out of town, he doesn't need a car. He's not going to be using the car. He just kind of is making sure it's okay, parked at his house. So the only duty of care that he's required to exercise is slight care, and he's only going to be liable for gross negligence. So a couple of examples, let's say while it's in his driveway, maybe someone in the neighborhood walks along and they key the car, well, that's not on my brother. That's someone else that caused that. He didn't do anything to kind of, cause damage to the vehicle. So he's not responsible. So when I come back and I see there's damage to my car, that's on me. I have to take care of that. I can't expect my brother to pay for that. Gross negligence might be if, when he, starts the car up once a week, maybe he, started the car up and then got out and left the car door open, and he just went back inside the house and fell asleep for a few hours. That would be, most likely considered gross negligence, because then what if someone was walking through the neighborhood and they saw this car that was, door wide open, vehicle running? Someone might just hop in and go for a joyride and then cause damage to the vehicle. So in that context, that would elevate, my brother to having liability at that point. The next example, where it's the sole benefit of the bailee, here the bailee is liable for the slightest of negligence. So again, with the car, if I let, my brother, if I loan him a car because he doesn't have one for some period of time and he's not paying me, so I'm just being, trying to be a good brother, he's going to be responsible for the slightest of negligence. So any type of minor fender bender, scratch and dent, to, worse, he's going to be responsible then while it's in his possession and care. The last one, which is the mutual benefit bailment, that's where we're just going to expect out of both sides just reasonable care, and they're only going to be liable for what's considered ordinary negligence. So the car rental example, think of all the different major car rental companies. They have a responsibility to make sure the vehicles are being properly maintained. So, every so many thousands of miles, they get an oil change, they check the brakes, they check to make sure the vehicle is in good working condition. That's a responsibility they have as part of the bailment agreement that's mutually beneficial. The person who rents a car, whoever they are, they're the bailee, and they're responsible to exercise ordinary care or reasonable care in that situation. And so, while you drive around your car, we know, you park at a shopping center, someone might, open the door, adjacent to your vehicle, and they might cause like a minor scratch, that would probably be considered just reasonable, that's ordinary wear and tear. If you are driving reckless, if you're intoxicated, you can imagine if you're texting and driving and then you cause an accident and there's damage to the vehicle, then certainly then you would be responsible for that. So overall, just big picture, make sure you understand the three types of bailments that exist, and we're looking at, who's the one that's benefiting. Is it benefiting the bailor, which is the owner of the property? Is the bailment agreement benefiting the user of the property or the bailee, or is it a mutual beneficial arrangement? And then based on that understanding, then we know how to apply the duty of care if damage comes to the property. In terms of duties and rights of the bailee, so obviously if you're the bailee, you must perform whatever their part of the contract is, so again, depending on the classification, they have to exercise a standard of care based on the type of bailment, and then they must return the identical property. So, again, if I'm loaning my car to my brother, or if you're renting a car from a car rental company, we want our same car back. We don't want a different vehicle. So that's, all part of what's blended into the agreement. When we talk about breach of duty, the bailor may sue the bailee if the goods are not redelivered according to the agreement. If we're referring to a mutual beneficial bailment, then the bailor is under a duty to furnish goods that are reasonably fit for the purposes that are contemplated in the agreement. So that's what I referenced earlier when I had discussed, maintenance requirements of car rental companies. They have to make sure that, the vehicles are properly being maintained. Check the brakes, check, change the oil, check the radiator, all the fluids in a car, that kind of thing. So as they do rent those vehicles out to different users, that they're, being well taken care of. That is a responsibility that the bailor owns. In this chapter, the author also discusses warehousers. And when we talk about warehousers in this context, we're not talking about warehousing facilities for you and I as individuals or consumers. So all of those U-store places, that is not really what we're talking about here when we mention warehousers. Warehousers in this context is in reference to commercial warehousers that are, offering warehouse space to other commercial tenants. So, if you own a company and let's say, part of what your company is about, you sell physical products. Maybe you get a shipment in and you don't have enough storage space for that particular inventory. So you need to off-site it temporarily, maybe for a few days, a week, a month, whatever the term is. And so you want someplace secure, so you'll go to a commercial warehouser, and for whatever you agree upon, in terms of the rate of compensation, then the warehouser will store whatever it is that you need to store. Is it just something that requires, no, climate control, or is it sensitive enough where it does need, maybe air conditioning if it's in the summer or heat in the winter? If we're talking about warehousers, they're regulated under UCC Article 7, which is, that under that article of the Uniform Commercial Code, we're talking about documents of title. But what the warehouser will do is they'll conduct an inventory of what is deposited there from whoever the business tenant is, and then they will issue a receipt. And that receipt will indicate, as you can kind of see in the example here, it'll give an item by item analysis. So it's a detailed inventory of this is all the things that are being stored here. That warehouse receipt is considered a document of title. And the relevance of that I'll get to in the next slide. But it's important to understand that the warehouse receipt that is issued or generated from the warehouser and given to the representative of the commercial tenant, that document is very important, and it should be kind of safeguarded because that is, again, evidence of title to the goods that have been deposited. So the receipts are usually going to provide for like the location, the date of issuance. There's probably going to be a series of like consecutive numbers if we have different inventory batches. There will be a specific indication as to the negotiability of the warehouse receipt, and that's going to be key to understand because if we're talking about negotiability, we're talking about transferability. If you know you're going to come back and reclaim that inventory in a few days, a week, a month, whatever the time window is, then negotiability may not be as of importance to you. But you may also be thinking, well, okay, I bought this inventory. Maybe it was part of a closeout. You got a good deal on it, and so you're thinking about what am I going to do with this inventory. If one of your potential options is that you might just resell it to someone else, like another business, then you're going to want to make sure that the warehouse receipt is indicated as being negotiable because then it's going to make it easier in the transfer process from one owner to another because remember, that receipt is a document of title. So that's key to remember. So in terms of the negotiability term that's in the warehouse agreement, if it's non-negotiable, what that means is on that warehouse receipt, it will specify a designated party of the company who deposited the inventory who must be there when the goods are reclaimed or picked up. So maybe it's your manager on site of whatever that business is. Maybe it's the chief acquisitions officer, a purchasing manager. It could be whoever you designate. Then their name will appear on the document of title, that warehouse receipt. And when you go to reclaim it and pick up the goods, that person will have to be present, and they'll present the warehouse receipt, to verify, their identification, and then the goods will be released. So that's fine. If it's a negotiable warehouse receipt, then it won't necessarily specify a named party. What it will do, it'll indicate maybe to order or to bearer. And what that means is that anybody who has that warehouse receipt can go and just pick it up. So that's why, if it is a negotiable warehouse receipt, it makes it very easy to transfer it if you do want to sell it without having to pick up the inventory. You can just, if you find a buyer, you can just basically say, okay, bring me a check or transfer or wire me the funds for what we've agreed upon. And as soon as I have it, then I will just either hand to you physically or I'll overnight it to you, however you want to deliver it, the actual warehouse receipt that just says to order or bearer, and then you go pick it up. I don't even have to deal with it then. So you can see how, having it be negotiable makes it easier for transferability. That's critical. If you take business law 2, we talk more about other examples of transferability in reference to negotiable instruments. But here, all we're talking about are warehouse receipts. So again, if you have it as a non-negotiable warehouse receipt, you can still sell it. It's still transferable. It's just that whoever the buyer is, the named party on the receipt is going to have to show up when the buyer goes to pick up the goods. And so, not that that's an insurmountable in terms of trying to coordinate schedules for that to occur. But sometimes it's just easier to just have the receipt be negotiable, and then whoever buys it, you just give them the receipt, and then it's their problem. You don't have to worry about it anymore once you've been compensated. If we're looking at a possible limitation of liability by the warehouser, since we're looking at transactions that are between two businesses, essentially, the warehouser is a business and then the commercial tenant is, also a business. The law does allow businesses to kind of offset liability more than if you were dealing with individual or consumers. There's a variety of consumer protection statutes that exist at the federal and state level, depending on the state you're in. And so, if you're dealing just between two companies, you have a greater ability to say, look, I'll cut you a price break on storage costs at this warehouse if you waive off my liability for, fill in the blank, if there's a fire or if there's some other kind of damage. Usually the only thing that, we're concerned about though is if you're trying to waive all liability, where it's like, theft or, damage or, you can imagine all the possible random situations that could arise. And if you're just trying to waive off all liability, that's can be suspicious, if something does happen to the goods in question. If the depositor, meaning the business, if they insist, no, I want you to be liable, then, obviously whatever the standard rate is, then that's what you're going to charge as the warehouser. You can't say, well, I'm not going to, offer storage services to you unless you waive off some liability. That's not going to be permitted. When we look at carriers, and I know we've talked about carriers before in this course, carriers are just, the party, the entity that is helping, facilitate the transfer or movement of physical goods from one place to another. So it could be going across the street, it could be going to the other side of the planet, so that's all that we're talking about with carriers. There are generally three types of carriers. There are common carriers, there are contract carriers, and then there are private carriers. Common carriers, they furnish and transport goods for whatever the stated price is, and they offer their services to the general public. So you could be an individual, you could be a business, you could be a nonprofit, you could be government. And, if you're relying on a common carrier to ship whatever it is, then that's what it is. So it could be like FedEx or UPS or maybe the United States Postal Service. Contract carriers, they also furnish transportation of goods, but usually it's in regards to maybe something that's industry specific. So, again, draw on your own knowledge. Think of, as you kind of travel around, in your day in and day out lives, sometimes you see different types of commercial vehicles on the road. And so it could be, a traditional semi-truck, so that would be an example of, that could be a common or a contract carrier, or it could be a private carrier, which I'll get to that in a second. But then you also sometimes see specialized types of trucks. Think of ones that transport gasoline, so they tend to be kind of oblong shaped, and you can tell by, the warning labels that are affixed on the sides of that type of vehicle that they're transporting, fuel. You can't transport any other type of substance in there or any other type of product because it's designed to handle just liquid cargo. Same thing if you see a flatbed truck and maybe, stacked up on that flatbed truck are like logs, like trees that have been cut down. Again, it's you're limiting yourself in terms of the type of goods that you can transport if you have specialized vehicles like that. And that's usually what's meant by contract carriers, because a lot of them tend to be very industry specific. So they have a fleet of vehicles that can handle, fluids. There might be another company that handles, more rugged type raw materials that could be like trees or something to that effect. The last type of carrier listed on here are private carriers, and a lot of companies try to internalize, at least in part, shipment costs so they can gain economies of scale and maybe, gain some greater efficiencies and save costs. And, again, think of, as you drive around town, if you've noticed this, a lot of different companies have, at least in part, their own fleet of vehicles to help transport goods around. So I've seen trucks, that are Walmart, on the side. I've seen Target. I've seen CVS. I've seen Walgreens. All different Publix. I've seen all different kind of private carriers that are on the road. A lot of those types of, especially the major companies, what they usually will do is they'll have regional distribution centers. And at those distribution centers, that's where manufacturers will use common carriers or contract carriers to get the goods to those distribution centers. And then from the distribution centers to individual retail locations, that's where a lot of companies will then draw upon having a private fleet of vehicles. So again, it just depends on, what the company, what their priorities are and what their particular focus is. But these are generally the types of carriers that exist. If you're talking about a bailment agreement, to kind of go back to what we mentioned at the beginning of this chapter, common carriers and contract carriers would be considered a bailment agreement in part, even though they are shipping stuff. You are giving them possession, not use, permanently. It's not a permanent transfer. You're allowing them permission to possess that property. And obviously, in that case, the stated purpose is to transport it for them to whoever the ultimate buyer is. So regarding common carriers, any types of warranties that they provide, when you think of like the bill of lading, that's the document evidencing that there was the receipt of goods for shipment. They're also warranting that the transfer is effective and there's no knowledge that would impair the worth of the bill of lading. The rights of the common carrier, they certainly have a security lien interest for any unpaid transportation services. Maybe it's being shipped COD, cash on delivery. And so until they actually get payment at the delivery end of the transaction, they have the right to kind of hold on to that property until they've been properly paid. Their duties as a common or a contract carrier is to simply deliver the goods as agreed. So, what type of containerization is required? Does it have to be refrigerated or climate controlled or not? Is there any type of specified delivery? Is it overnighted? Is it, just whenever it gets there? What are the terms? And so those would be the affirmative duties that these carriers have. Liabilities of the common carrier. Under common law, they are absolutely liable for loss of damage to all goods, which, as you can imagine, that seems to be a very overly burdensome responsibility. But in the context of understanding the exceptions that arise, so, I'm just going to read off this list, loss caused by what's considered like an act of God or maybe nature, so if there's a tornado, if there's a hurricane, if there's some, storm or earthquake, who knows what, that causes damage to the goods while they're being transported, then the carrier is not going to be responsible because that's an act of nature. If it's an act of public enemy, so think of, like 9/11 type events or other terror events, which hopefully we don't have to go through, but, it's a random world at times. But again, that's out of the control of the carrier, if they're under attack for some reason. If there's an act of public authority, and what's meant by public authority is any level of government. Many of you are probably too young to remember the days and weeks in the aftermath of September 11th, 2001. I recall very vividly, there were a few things that were very dramatic in terms of changes in our society. For about 7 or 8 days, all airports and all seaports were shut off. They were closed. And so you could imagine if you were a cargo ship and you were delivering, let's say, produce or, perishable foods from, Latin America, Europe, or who knows where, a lot of those, containers on those cargo ships, those perishable goods just went bad. And that's not the fault of the carrier because they're following whatever the law was at the time when, when government said we're shutting down our ports, our airports, and our seaports. So that's what's meant by act of public authority. Act of the shipper here, and I think this is what kind of confuses students sometimes. When I say shipper here, this is the person who brought the goods to the carrier for shipment. So when I say shipper, it's not the carrier. The shipper is the one who, maybe they boxed up everything and they said, okay, let's take this down to a cargo ship, to FedEx, to UPS, to the post office, to whatever. If they didn't properly, containerize things, or if they didn't properly, request climate control, because of things being temperature sensitive, then that's on them. That's not a carrier problem then at that point. And then, of course, certainly the last one is a catch-all, just the inherent nature of the goods. Some goods are just very delicate, very fragile. They can be prone to spoilage or deterioration in shipment. And so if that's the case, then again, that's not the responsibility of the carrier. So even though that's a big standard we hold them to, that idea of absolute liability, it's offset by a lot of exceptions. So when we talk about liabilities of the carrier, when you think of like limitations of liability, you can have liquidated damage clauses and exculpatory clauses in contracts that we referenced in Chapter 20. Again, they just have to be reasonable. If you have any type of claim for damages, generally under the UCC and other statutory provisions, you're usually given up to 9 months to file a claim. And 9 months is, it may seem kind of arbitrary, but I think part of the policy idea behind that 9-month window is that, once things get delivered, that's when the 9 months, that kind of like clock starts ticking. And you should discover within 9 months if something's been damaged, and then if it is, then you can file a claim at that point. But if you wait 9 months and a day, then that's like a statute of limitations, and then you're precluded from bringing a claim or cause of action, even if you have a perfect case of it. So always remember that statute of limitations, that idea of like there's this clock that's ticking, and if you go to the deadline and go past it, then you're going to be prevented from seeking some type of remedy. Hotel keepers are an interesting type of industry because this actually is an industry that has been in existence for millennia across the planet. The idea that for persons that are traveling, they need lodging, a place to sleep for a night or a few nights, whatever the agreement is. And so normally the guests that are staying in a hotel, they're referred to as guests. They're transient, meaning that everybody knows that they're there just for some temporary stay. Again, it could be one night, it could be a few nights a week or whatever, but they're not going to be living there permanently. If they live there, long term, then they kind of change their status, which I'll talk about. Normally at common law, hotel keepers were, again, like carriers, absolutely liable for loss or damage to guest property. But we've backed off a lot of that, especially in parts of the country that generate a lot of tourist activity. So Florida, for example. If any of you have ever, stayed in a hotel, you probably notice it's usually on the back of the door as you go into your room. Or someplace very visible. It'll kind of, list out like statutory information and, what obligations exist or don't exist for the hotel. And so for areas of the country like Florida, California, Hawaii, those are just 3 states that come to mind that generate a lot of tourist activity. So there's pressure in those states to provide, some insulation from liability, so that if, maybe something is stolen that belongs to a guest, we're going to try and push responsibility off on the guest instead of saying that that's the hotel's responsibility. Intermixed with this, obviously I discussed the theory, but then I also sometimes like to reference the reality. And so if you're a hotel, or an innkeeper, and you have a guest that suffered some type of harm, so, maybe something was stolen or damaged, it may be in your interest, you could say, well, the law protects me and I don't have to give you anything. You could just kind of be, kind of hardball, that perspective. Or you could say, look, I'm really sorry this happened, we can comp you a night, or, if you come back, and stay with us again, we'll give you, a free stay or something, as part of maybe extending goodwill and having good guest relations. So there is a lot of wiggle room if you're a hotel or innkeeper, whether it's a small hotel or if you're some major resort, somewhere, here in Central Florida. You have a lot of different options at your disposal. And so, everything is going to be very situational specific. I don't think you always want to default say, well, I don't have to cover this because the law insulates or protects me, because then you're going to probably pass on some bad will with that particular guest and lose maybe future business. If you work with them and you're kind of accommodating and you try and, maybe give them some type of compensation, again, a comp a night or something, then, they may realize, okay, sometimes these things happen, and this particular hotel took care of me, and so, I'm going to be loyal. So again, those are all different things that you have to take into consideration. This is an example. I don't expect you to read all this, but this is Florida statute regarding liability for the property of guests. And so they break it up into like these two major sections. And the top section talks about if you want to put like for safekeeping in the hotel safe. And let's say things end up disappearing from the hotel safe. You can see here that they're liable to a maximum of $1,000 if a loss occurs in that situation. We're not talking about those safes that are in like the closets of hotels and individual rooms, but like the actual safe that would be in the office of the hotel, like office manager. So even when it's under their total control, Florida, and this is not uncommon. A lot of other states that have a lot of tourism, based, activity, they try and give a lot of deference to the innkeeper. The other paragraph, the second one there, again talks in general about, if there's loss of guest property, then usually the cap of responsibility on the hotel keeper is going to be anywhere from $500 to $1,000, depending on some of the specifics of what occurred. We're not talking about like intentional torts. We're not talking about, if a hotel employee, intentionally assaults, think of all the crazy things that could happen. We're not talking about that. We're just talking about, like the loss or harm to property, physical property of guests. This is the last slide. It's just one problem that I want to discuss. And this is a common type of situation that occurs in a lot of, metropolitan areas where, you're going into like a downtown area for, the day, the evening, whatever the occasion, and you're looking for a place to park. That's always, a thing that's on everybody's mind. You want some place where, one, that you're not going to get ticketed or towed. Two, hopefully wherever it is that you're parking your vehicle, it's relatively going to be safe and secure, so that when you come back, your car will still be there, hopefully. And so here the problem is that there's this public parking place called Rhodes, Rhodes parked his car at Pioneer parking lot. Sorry, I misspoke there. And so he, like many kind of places where you park, you initially pull in, pick a spot, and then you go to a machine and enter in maybe like your license plate or your spot number, and then you pay whatever, however long you're going to stay there, and then it generates a ticket for you. And a lot of times you either keep the ticket or you maybe put it on the dash of your car. Anyway, on the ticket it says, "Notice this contract limits our liability. Read it. We rent space only. No bailment is created." Rhodes parked the car himself and kept the keys. There was no attendant at the lot. The car was stolen. Rhodes sued the parking lot on the theory that it had breached its duty as a bailee. Remember, in a bailment, the bailor is the owner of the property, and so Rhodes owned his car, and his car was stolen, and so he's saying that Pioneer parking lot was the bailee, the one that had possession of the car. That's at least his argument. And he's saying that because his car was stolen, then the parking lot should be responsible to reimburse him the value of the vehicle. And so the question is there a bailment? Why or why not? And, remember, if we're talking about a bailment, if there is a bailee, someone who has possession of your vehicle, they need to be able to have actual possession and use or control over it. If they don't, then it's going to be a stretch to kind of identify them or label them as a bailee. And here in this situation, the fact that it's unattended and that you kept the keys and all you did was put money in a meter and it spits out a ticket, so that, and the only purpose of doing that is that you have a place to park your car and that it won't get ticketed and or it won't get towed. That's all that this is. If you were to change the facts a little bit, I've parked my car, for example, at a lot of different parking lots in downtown areas over the years. And sometimes it's just like this, where there's no one there. And so I know in that instance, it's not a bailment because there's no one there to take the keys and hold on to them. I have parked at parking lots where there is an attendant, and I park the vehicle myself, but I give the attendant my keys in case they need to move the vehicle because, again, sometimes they kind of jockey around, cars depending on, trying to make room as more cars come in. And so in that arrangement, that is a bailment because they have the actual keys to the car. The other example that I also contemplate, and I'm sure we all have been there, is when you actually have a valet. So, you park somewhere and you get out of the car and, they give you a ticket, and, whether it's for a restaurant, a hotel, a resort, whatever it might be, they then go park the car for you. And then you go do whatever it is. And then when you're ready to leave, you present your ticket and then they go retrieve your vehicle. That is a bailment also. But in this case, purely in and of itself, the fact that you're parking your car and just, putting money in a machine and a ticket spits out so it doesn't get towed for that time window, that is not a bailment. So anyway, I hope this helps. As you have questions, as always, please feel free to reach out to me anytime, and have a wonderful rest of your day. Thank you.